All right. Am I audible? All right. Hi, everyone. All right. Can you just all brief me about what did you learn in the last session? Anyone?
Ma'am, breach of contract.
So, did you cover everything about breach of contract or attestation and other things as well? Like while reading, so I have two questions to ask. You all said that you have also learned about registration of contracts. Did you learn about attestation of contracts as well? And in yesterday's session, you learned about breach of contract. Did you learn about damages as well?
No, ma'am, we have not gone through the damages.
Okay. All right. So, I won't be entering into the theoretical part. Damages we will cover subsequently with the as we proceed with the clauses and other things. So today we are going to directly start with the boilerplate clauses. How we are going to manage it? First, we'll understand the meaning of the clauses and the importance of it in a contract. Once we have done that, we'll proceed to the steps of how to draft a contract and how does a MSA look like and other contracts. Because if we follow this method, it will be easier for us to cover all the type of contracts. So firstly, we are going to understand about the clauses. Yes, Bhakti. But Bhakti, you have raised your hand. Do you have any query?
Hello.
Yes, hi Bhakti, you are audible.
Sorry, ma'am. Actually, I just logged in and that raised. So sorry for it.
Okay, all right, no problem. All right, let me know once my screen is visible. Is my screen visible?
Yes.
All right. Okay. So, as I
Yes.
discussed earlier, today we are just going to understand about the clauses, which are important clauses used in almost all type of contracts. So, what do you understand with clauses? What are they? Okay, clauses are paragraphs that define the rights and obligations of each party. They mainly cover the core subject of the contract. And a contract is mostly divided into four parts. First will be your operating clause, second is your boilerplate clauses, third will be your risk mitigation clauses, and fourth is your payment clause. The operating clause are the major clauses which describe about why the contract is being entered. The service area and everything is covered in the operating clause, which describes the material content of the contract, like let's say if two people are entering into for the purpose of creating a software, the operating clause will explain the material or the intention of the contract. Next, we have boilerplate clauses. These are the clauses we'll be discussing in today's session. Third is risk mitigation clauses. These clauses majorly eliminates the risk. I'm sorry if you have raised hand or anything, just directly unmute and say, because I cannot see check the meeting again and again. All right. So risk mitigation clauses are there to eliminate the risks in a contract. It mostly deals with what are the criteria to be followed, or what are the steps that can be taken by both the parties to reduce the risks. For this payment clause, as the name suggests, it mainly deals with the payment procedure. So we'll be discussing all these clauses one by one. Let's start with boilerplate clauses. Any doubts so far?
No, ma'am.
Okay, known as intent. And this one, like over here in the example, term and duration of the agreement. This part will be known as your intent. And the part where the description is given date or the tenure for which the agreement is effective. So let's say duration is for a period of 30 days, and this overall clause describes the term of the contract, and the duration, that is 30 days, this will be considered as entities. All right, I think so you guys don't have any doubt on this part.
Yes, ma'am.
Okay, so what are boilerplate clauses? Any guess? It's written on the screen as well, so you can feel free to guess or give me your assumption about it. Okay, let's do it this way. Give it a read and let me know what did you understand about it. Okay, now anyone would like to make a guess? Okay, so the word
Ma'am, the clauses that are mentioned mostly in stock market, there has an asterisk remark in a small letters. Would that be a boilerplate?
you are you talking that clauses mentioned in a stock market agreement or something?
Yeah, yeah, yeah.
Okay, in that case, no. But thank you for attempting at least. Anyone else? All right. So, the boilerplate term, this came into existence in the year 1950. It comes from origin of steel plates, like you know. Yes, Bhakti, you have raised your hand again. Okay, you create certain standard for something. Even while, let's say, manufacturing a steel or something, you create a standard of it, that this will be your print and this will be your steel plate, and your things will be in this particular dimension or area. It should be specified. So boilerplate clauses are the clauses that are specified and standard. These clauses are majorly for the purpose of reducing the risks in an agreement, and describe about the duties and obligations of the parties in case of this disasters mainly, or any problem occurs in a contract. So let me show you one example of the same. This is example of one of the agreement. I'll show you boilerplate clauses, how they are in an agreement. So we'll be dealing with how agreement is framed and all, but majorly all the boilerplate clauses are mentioned at the end of the agreement. Let me type one for you. Right. So, see, all the clauses which are mainly for the purpose of describing the rights and obligations of the parties in case of any disaster or problem arises are known as boilerplate clauses. The reason all the agreements have these clauses are they create a particular format of it in order to avoid any ambiguity in the terms and conditions. Mostly all the companies or law firms, they create a particular template or set of clauses ready in hand to add in all types of agreements. Because this way, if you're going to type the clauses again and again, it may happen that you fail to add a certain point or condition, and because of which you have to bear up with the damages. So your major form of boilerplate clauses are your force major clause, governing law and jurisdiction, limited liability, termination, notice, waiver, entire agreement clause, severability clause, representation and warranties, assignment, further assurance, and confidentiality clause. Mostly all these type of clauses are considered as boilerplate clauses and are very essential to be mentioned in all type of contracts. Mostly your master service agreement, consortium agreement, and all these type of agreements. Bhakti, you're raising your hand again and again. Do you have any doubt? Okay, all right. So the major key points of the boilerplate clauses are they are standard clauses. They are used at the end of the agreement. They are routinely included. So they are mostly included in all types of agreements, and the main purpose of them are they give solution to the problems or disputes that may arise in between the parties in an agreement. So far, any doubt? Okay.
No, ma'am.
Thank you. So your first one is force major clause. Have you ever heard of this word? Yes, no, just yes, no.
No,
Anything?
ma'am.
Okay.
That's it.
So your force major clause is a type of clause which is determined from the word French word that is superior force. This word came from the French word superior force, which means any act which is out of control of human being and we cannot control it. You can say act of God or any disastrous event where we cannot control the conditions or circumstances, and because of which the contract may get affected. All those things are covered in force major clause. So can you Think of any of the events so far which was out of the control of human being.
Earthquake,
Good. Others,
COVID
I need,
was
sorry.
COVID ma'am.
cyclone,
COVID corona.
Okay, COVID, you are saying. Yes, that is the recent one. Uh, more, give me more examples, at least five examples I need.
hmm,
Wait,
Okay.
cyclone, flood, strike.
Yes. So these events are out of the control of human being, and because of this, it may happen that you are unable to provide deliver the services. So let's take an example. A and B entered into a contract to again develop a software, and recent example of COVID happened. COVID-19 came, and because of which offices have to shut down and everything. So what will happen in this condition? um, A won't be able to deliver the software on time. Let's say the period was 60 days, and because of the COVID, they had to shut down the office for a period of 15 days. Under this situation, A will be required to extend the period, because in case if he fails to deliver the software, he he'll be liable to pay for the damages that is caused to the B. So, the force major clause describes that it prevents the parties from any liability to perform contractual obligation when performance is not possible owing to an event or circumstance beyond the performing party's reasonable control. So, A tried all its means to continue with the production of the software, but because of the COVID situation, he failed to. This condition will be covered under the force major clause. This particular event, the force major events mainly include an act of war, invasion, armed conflict, strikes or lockouts, flood, cyclones, lightning, earthquake, act of God, etc. The exact scope, nature, and application have to be specific and clear. A standard clause may not fit in all transactions. So, the main thing is your force major clause should particularly describe all types of events which are covered under Act of God. It can be in form of political events such as strikes, lockouts, or your war, invasion, etc., or it can be non-political events which will come under the category of other events such as your flooding, cyclone, lightning, etc. The next thing is why your force major clause should be described, is that this clause is not defined by law. Like, the law does not provide any particular provision for this clause. It is mutually agreed between the parties to add this clause in order to avoid any damages that may occur, to protect them from the liabilities. So, you can read it from here now. It is also pertinent to understand that an affected party, before triggering the said clause, must have taken reasonable endeavors to mitigate the outcome of the event. So, we'll take the example of the COVID one, which we discussed between party A and party B. Um, Coming back to the same example, now the production is delayed for a period of 15 days and all the offices are shut. It will become duty of A. First thing will be to specify about it to B that this situation has come up, and because of this reason we had to shut our offices. However, it will be duty of A to take major actions how he'll be able to produce B to reduce his damages. So what A can try is A can try doing work from home, like providing laptops to their employees as soon as possible, so that they can start working from home first, and then he can focus on delivering of the software. So these all are the steps that should be taken. And if A fails to at least notify the party or within a reasonable time limit, and with proper, description that why he failed to notify earlier and everything, A should take all the steps in order to mitigate the losses. These are the major conditions in a force major clause. Your force
Ma'am,
major. Hmm?
what if this section, I have not mentioned this section in the contract then? The force major
Okay,
clause.
then it will become more of like party can be held liable. However, they have to again approach the court and ask for remedies and justify everything. But if you're mentioning this clause, it will become very easier for both the parties to resolve the matter instead of bringing it in the court. It will save time and costing and everything. That's why parties mention this clause. However, you can claim for damages, but of course if you are having reasonable reasons that why it got delayed, so there are high chances that the court will eventually give decision in your favor.
Okay, ma'am. Thank
Okay.
you.
Yeah. So the major key points that are required to be mentioned in this type of clauses are your definition. The clause should specifically define what comes within the category of act of God, that is flood, lightning, earthquake. It should define what will come under the events of political events, such as invasion, strike, loss of property, and notification procedure, like how the one party is required to inform to the other party and within what time frame such notification is required to be given, and also cover what will happen if the party fails to notify within a specified timeline. Do they have to provide a major reason for the same, or till what extent such timeline can be extended, and everything. Next, your will be, it should also mention about the allocation of cost. So, majorly covering two events. If force major occurs before effective date, who will be the party bearing the charges? If force major occurs after the effective date, that is effective date. Do you know what is effective date? Guesses what is an effective date in a contract?
Ma'am, the date at which the contract took place. Or
Okay, so I think so. I should explain the type of dates in a contract first. There are I hope so you all won't get confused if I cover the date part first now. Should I?
yes, ma'am.
Okay. So there are total three type of dates in a contract. First is your effective date, execution date, and majorly these are majorly. Let's first discuss about effective and execution date. Your execution date is the date on which your contract is signed, and your effective date is the date on which your contract will come into existence or the services will start. Another example of this can be again a let me take one of you, Shantinu. I entered into a contract with you, like we both signed a contract on 12th August. But there will be the specified date known as effective date in the contract. Let's say this contract shall be effective from the date 15th August. So, which will be your execution date and effective date under this situation?
Ma'am, effective date is on 15 and execution date is on 12.
Yes, right. So the date on which you sign the contract, that is execute the contract, will be known as your execution date, and the date from which your contract is coming into existence will be known as effective date. That from this day, or you can also say payable date, like from 15th till the duration of the contract 60 days, your contract will be calculated, and those will be your payable days. So that will be your effective date. Or the third type of date is commencement date. So commencement date is a date from which your services will start. It can also happen that your, let's again take software. You entered into a contract on 12th August. Your contract will become effective from 15th August, but your service commencement date is 16th August. So it is from 16th you'll start providing services for production of the software, not before that, even though your contract became effective on 15th. Doubt so far?
Ma'am, can be like effective date and commencement date can be done in one day.
Yes,
Like,
they can be done
can
in one day as well. So if a commencement date is not specified exclusively, you will consider effective date as commencement date only. Or if the it can also happen that your effective date or commencement date both are not mentioned in a contract, or any particular date is not at all mentioned in a contract. In such scenario, you'll assume that this contract got effected on the signature day itself, like on the same day it was signed.
okay, ma'am.
Okay. Others, do you have any doubt? All right. Moving on to the force major specifications. Um, it should mention the allocation of cost, means which party will be bearing the cost in case force major event occurs. If the event occurs before your effective date, or if the event occurs after effective date. We'll be reading it in the example. Your another point will be disclamation. That will again, what will be the damages to be payable damages in case party fail to take reasonable actions. I'll show you one example of this as well. Last point is your consultation and mitigation, how the parties are going to handle the situation and mitigate their losses. So I'll be sharing another example of this. Is my screen visible?
Yes, ma'am.
Okay. So this will be your force major clause in an agreement. Your clause will look like this. Of course, there will be numbering to your clause. Firstly, you'll describe about the events that are covered under force major. As you can see over here, we have divided the events into non-political events and other events. So let's take 2 minutes to read the type of event so that you all can have a better understanding about the same. A force major event means any event or circumstance or a combination of events and circumstances referred to in this clause which is beyond the reasonable control of the affected party. Such party could not have prevented or reasonably overcome with the exercise of reasonable skill and care, does not result from negligence of such party or the failure of such party to perform its obligation under this agreement, is of an incapacitating nature and prevents or causes a delay or impediment in performance. And such events include non-political events, act of God, including earthquake, flood, inundation, landslide, exceptionally adverse weather conditions, storms, radioactive contamination or ionizing radiation or biological contamination. Next, again, strikes, lockouts, backout, labor disruptions, or any event or circumstances of a nature analogous to any of the foregoing. And under other events description, it mentions an act of war, whether declared or undeclared, like currently Which country had a war? Come on. Which two countries were in war? Sorry?
Russia and Ukraine.
So do you think that event is covered in the force major clause? Yes, it will be. So next will be once you have defined, uh, please go on mute now. Thank you. So once you have defined everything about the events, like what events are covered under force major clause, next step will be defining the this thing, how the parties are going to notify to each other. So there will be a separate section, or you can directly mention in a form of a date where you'll mention like the affected party shall notify the other party of a force major event within 7 days of the occurrence of such event. If the other party disputes the claim for relief under force majeure, it shall give the claiming party written notice of such dispute within 30 days of such notice. Such dispute shall be dealt with in accordance with the dispute resolution mechanism in accordance with clause. Upon cessation of the situation which led the party claiming force majeure, the claiming party shall within 7 days hereof notify the other party in writing or the cessation, and the parties shall as soon as practicable thereafter continue performance of all obligations under this agreement. So if you'll read, you'll understand that the notification clause over here says that the party, once the cessation period or the period during which such calamity arise is over, it will the other party will be obliged to inform the other party that uh, within a period of 7 days, he should pass on the notification that why the services got delayed or why he want to use the force major clause in such scenario. Or it also mentions what will happen if the other party wants to use their force major clause and file a case against it. Means both the parties should take reasonable action. Let's say the A was obliged to notify to party B for that, let's say, flood occurred in his area and he wasn't able to do the services or provide the services for that certain time, and even after 7 days that everything is in back to its normal situation now, and A fails to notify to B. It's been a month from that situation and he didn't even make an attempt to contact B or anything. A B has the right to file a suit against A, but even if he is going to file a suit against A, he have to provide a 30-day notice period that he is going to take this step because A failed to notify him about such event.
Ma'am, can you explain this again? 30 days period one.
Okay, sure. So if A fails to um, do his duty of notifying B, let's take again COVID-19. Okay, offices got shut down and everything, and you had to deliver your product within a period of 30 days, and it's been 30 days already, and because of those 30 days and the COVID, offices were shut down and everything, and it took you, like, let's say 30-day period is already over and in between you fail to communicate to B that this situation has occurred and offices are shut down, we will not be able to provide you services. If you fail to notify to B after 30 days, if you all remember, within this time period government had all the offices and everyone started circulating regulations like, okay, if we cannot work from office, let's start working from home. Schools, colleges, everyone, they all started finding solutions how we can lower down the risk and continue with our routine, right? We all took certain steps in this scenario. Did we or did we not?
Yes, ma'am. Yes,
Yes.
ma'am. Yeah.
So if do you think these all things could have been covered within a period of 30 days? 30 days are enough to cover everything, to find a solution or contact party B in this situation?
Yes, ma'am, definitely.
Yes. So if the duration of 30 days is over and I fail to contact this party B, that because of this situation we won't be able to deliver your product at time, or offices were shut or anything, I fail to notify him even after 30 days and additional 7 days notice period. So, if I fail to mitigate, B has all the right to file a case against me because I didn't take reasonable action to notify him about the same. So, in such scenario, when B decides that he is going to file a case against me under force major clause failure, he is going to provide me 30-day notice.
Okay,
See,
ma'am. Yeah,
if
ma'am,
the other,
understood.
okay, all right, thank you.
Yeah.
Any more doubt? So, your next thing will be allocation of costs arising out of force major. So, of course, if there is delay in delivery or delay in production or anything, both the parties will be accruing losses. First, that it because of the late delivery, the person will not be having money to except for the future projects, or if by the time you don't receive your product you'll also be facing losses because you are not able to work properly because you don't have your product so far. Both the parties are facing losses in such scenario. So your allocation of cost will exclusively mention which parties are required to bear the losses, whether on occurrence of force major event, whether it will be A responsibility to bear all the losses or whether it will be B's responsibility to bear the losses. So we can also divide this situation into two parts. Like, of course, we can simply write that in case of force major clauses, both the party will be responsible to manage their own losses and won't hold the other party liable to pay the damages. Okay, or we can mention, like, if the, let's say the force major event occurred before effective date, that is on the date the contract comes into existence, as example given with me and Shantanu. If we sign the contract on 12th August and the contract is effective from 15th August, and if in between any event occurs between 12 to 15, 13, 14, let's say an event occurred, and it won't be possible for us to start with the contract. In such scenario, the event is taking place before effective date. So we both have to bear our own losses and we cannot hold each other liable because so far we haven't even started working on the project. Are we clear till here? Yes, no. I'll take that as
Ma'am,
a yes.
before
Hmm?
before effective date, we have to bear our losses, right? Both the party have to bear the losses
Yes. Yes.
under, like, if such circumstances come.
Yes, in such scenario, we both have to bear our own losses. But in case event occurs after effective date, we can mutually decide that which party will be liable for the losses. We can, of course, we can frame this whole clause as per a mutual discussion between the parties. We can either include that if the event occurs after effective date, the parties will be liable only for the losses which are limited to the failure of services. um, let's say 15 days में जो services होनी थी, if I'm failing to provide that, I'll just pay you for those 15 days only and not beyond that. So, in example, you can read this: upon occurrence of a force major event after the effective date, the costs incurred and attributable to such event and directly relating to the project, force major costs shall be allocated and paid as follows. Upon occurrence of a non-political event, the party shall bear their respective force major costs, and neither party shall be required to pay to the other party any costs thereof. Means again, you can define cost based on events as well, event to event. Like in above example, I gave you 15 days services का failure हुआ है, तो we'll be just obliged to pay for 15 days. Or in case if any political event arises, let's say war arise हो गया है, so I won't be liable to pay you anything, जो हुआ हुआ, uh, let's settle the matter over here only, and you cannot file a case against me in such scenario. So it totally depends how parties want to decide this clause and include terms and conditions in the force major clause.
Get it, ma'am?
Okay. Okay, so with all these points of force major clause will be there. Mostly in not in every agreement you'll find that the force major clause is this descriptive. They automatically mention like what are the events that are covered under the force major clause and what will be the responsibilities of parties. They just narrow it down by framing like all the events occurring which are out of human control, the such as act of god, earthquake, lightning and everything. Both the parties will be liable to notify each other within a period of 7 days, and if they fail to notify to each other within period of 7 days, uh, they have the right to sue each other by giving a 30-day notice, or they can mention like all the damages, causes and claims of actions occurring due to force major. Both parties will be liable to bear their own losses, or party A will be liable to party B for all the costs and damages occurring due to force major. So they can simply provide it in form of one paragraph instead of providing it in different pointers and all. Clear?
Yes, ma'am.
Okay. Your next is this. Entire agreement clause. So, what do you think of entire agreement? What are we going to mention in this clause? All right. So, your entire agreement clause is a very essential clause. It mentions that all the details or all the communication made between the parties or all the agreements which the parties had entered before entering into this contract will be nullified or wouldn't be effective, or you can say that the it wouldn't whatever definition or rules and regulations that under this the present agreement is being mentioned, this agreement will be considered as an official agreement, and all the communications which we did earlier, they won't be considered at all. So, if you can read, entire agreement clause provides that the agreement in question, together with all annexures, schedules, exhibits, and attachment, constitutes the entire agreement and understanding between the parties with regard to the subject matter, supersedes any previous agreements, discussions, and understanding between the parties to the agreement. So, you can take an example that once let's say I before entering into agreement I had a conversation with prince that I'm going to charge him 30 rupees for each candle. I'm selling candles and I'm going to charge him 30 rupees for per candle. But in contract, after knowing that he has a demand of 100 candles, I'm mentioning that 25 rupees will the charge for per piece of the candles. So which conversation do you think will be enforceable, which is the more which conversation we are going to consider while making the payment?
Ma'am, can you repeat it once?
Okay, so
No.
I entered into an agreement with prince for selling candles. While having negotiations on call, we discussed that per price of the candle is rupees 30. Okay, 30 rupees per candle I'm going to charge from prince. Now, after knowing the mentioning everything that what are the requirements of prince and the quantity of candles he require from me, let's say he requires 100 candles. After knowing the quantity in the agreement, I'm mentioning that 25 rupees will be the charge per candle. So which amount do you think will be enforceable?
From 25 rupees.
Yes, 25 will be the amount enforceable because we are mentioning that in the agreement. So your entire agreement clause purpose is to nullify all the previous conversations which we had, and all the previous agreements which were entered between the parties, to make enforceable only the particular agreement which they are signing right now. So you can see.
Ma'am, if previously I've signed master service agreement,
Then it can happen the parties will nullify the previous master service agreement and enter into a new master service agreement. So in such scenario, they clearly have to mention in the preamble of the agreement that this master service agreement nullifies the previous master service agreement entered on 1st August 2023, and so hereafter this agreement entered on date 12th August will be effective and enforceable in the court of law, and the parties will follow the rules and obligations mentioned under this master service agreement. Okay, so while mentioning or nullifying that particular MSA, they are going to mention the date on which the parties had entered into that agreement, and uh, specify that they are entering into a new master service agreement with new rules and obligation and services.
okay, ma'am.
Okay, so your entire agreement clause purpose is that it excludes liability for any pre-contractual statements exchanged between the parties which do not form part of the executed agreement. This enables the parties to provide certainty to the agreed terms and also limiting possible claims from dealings outside the agreement. However, it is important to ensure that all the terms of any previous agreements and understanding are captured accurately and completely in the agreements. So, this is your example of entire agreement clause. One second. Give it a minute and read this particular clause. If you want me to zoom in, let me know. Done?
Now, what is SLA agreement?
SLA is your service agreement, service level agreement. So as I said, your MSA के under service agreement होता है. It can also be known as service level agreement, and your NDA is non-disclosure agreement. We'll be discussing the overall hierarchy of these agreements once we start learning about MSA. But for your understanding now is कि MSA, under MSA you get all the SLA or an annexure schedules. All the things are covered in one MSA. Done?
Yes, ma'am.
Okay. All right. So we will quickly cover the notice part. So what do you think of notice part? Of course, you all must have read about it or heard about it. Make an attempt. Guess what do you think of a notice clause?
Notice is basically the communication that is exchanged between the parties.
Yes, and why do you think it is important to mention this clause in a contract? To communicate what type of conversation do I have to send a notice to the other party?
Like in case of any delay or any problems occur
Yes.
from either party, in that situation we have to serve notice.
Yes, you're correct. Anyone else would like to add? Okay. So basically, there are certain situations where you have to send a notice to the other party. The reason why this clause is important, so that there's a proper procedure to provide the information to the other party and the concerned persons. The main purpose of this clause is to provide a time frame within which such notice is required to be delivered. Examples of situation when a notice is required to be sent is when the party wants to terminate a contract, that I no longer want to work with you, or when a party wants to add something in the services. They can also add a notice period for the same. Like, I want to add an additional service, and I'm giving you specified time limit within which you have to deliver me that service. Or so your notice clause will majorly explain about the time frame. Let's say before terminating the contract, the party will give each other 7-day notice time frame, or you can mention that which parties are required to be added while sending that notice. Like when you send a mail, you send mail to a particular party, right? If I'm, let's take an example: manager, employee, team lead, and employees. I'm giving you the hierarchy of the organization, and I entered into being the third party, outer party. I entered in a contract with manager of the company, and his name is mentioned in the contract. Whom do you think I should notify while sending the notice or termination notice? Whose name should be there when I'm sending a notice? Should I mention employee name, or should I mention the manager name or team lead name?
The manager,
Why not employee? Because employee is not the correct person to be informed, and if I'm informing him about certain thing, I cannot be assured that he's passing on the information to the manager. That's why under notice clause you specifically mention the name of the parties to whom the notice is to be delivered, along with the details. Under details there will be your address of the parties, contact number of the parties, and also your this thing, mail ID of the parties. It can happen if I'm going to file a lawsuit against the other party. The parties mention the name of the company, the concerned person of a company, along with the details, and also the name of the council of the company, and along with the details. So let's take an example: Tata Steel. If I'm under notice clause, uh, give me example of the other company which is entering into a contract with Tata Steel. Any company. कंपनी का नाम बोल रहे हैं. Give me
Wipro,
example. Yes,
Wipro,
great. Let's take Wipro. So under notice clause, I'm going to mention the details of both the companies. That will be name of the company, Tata Steel. Below that, let's say manager's name will be there. Anything, name of the manager will be Mr. Rao or anything. Below that there will be address section where I'll be mentioning the address and email ID of the party or contact number. Then below that, if sending a legal notice sent to the council, I'll mention the name of the LLP, ABC LLP, and address of the LLP and other details. Similarly, the details of Wipro company manager and address and mail ID will be there, and along with the details of their council. So your by this your notice clause will look like this. Any notice or other communication to be given by any party to the other party under or in connection with the matters contemplated by this agreement shall be in writing and shall be given by hand delivery, recognized courier, registered post, email, or facsimile transmission, and delivered or transmitted to the parties at their respective addresses set forth below. If to as in like DDL is name of one of the party, attention, this ATTN is the abbreviation for the name of the parties. Like if to DDA, I'm adding the name of the manager, Mr. Rao. I'm going to add details like his telephone details, fax details if there are any, email details, contact, and everything. With a copy to, so mostly when it is said with a copy to, they means send it to other important people. It can be your company counsel, or it can be your head manager or CEO, any other person. So you'll add with a copy to. If to the company, then send it to this management agency, fax, television, and other things. Telephone and other things. Sorry. Are we clear till here?
Ma'am, we have to send this notice through email or like through.
So the main purpose of notice clause is only to specify the mode through which you are going to send the notice. It can be in form of like over here you can see by shall be given by hand delivery, recognized courier, registered post, email, or facsimile. So you can specify clearly whether it is mandatory to send the information via mail or through a call or through by sending it by hand delivery. Okay, and over here under this example, you can see all the modes are covered, which will be considered as recognizable mode. If I'm, but one part cannot be, if I'm not specifying these details and I'm just sending a handwritten note and giving it to any of the employee, it wouldn't be considered as a proper followation of the notice clause. Okay, so your notice clause should majorly cover these 3 points, that is time frame within which the notice is required to be delivered, mode of sending a notice, that is your hand delivery, recognized courier, and notice parties, that is your name of the parties. Clear so far?
Yes, ma'am.
Okay, all right. Okay, so I think we are out of time right now. We'll be discussing more sections tomorrow. So keep your doubts ready meanwhile and do a little bit research on your end as well.
There are other things.
Clauses?